Good evening. You're watching The Right Stand with me, Poonam Burde. The Kashi Vishwanath Gyanvapi legal tussle has been going on for decades now. Today, it hit another milestone. Now, the original petition dates back to 1991. It sought the restoration of the Gyanvapi land to the Kashi Vishwanath temple. The claim was that the mosque was constructed under orders of Aurangzeb by tearing down the Kashi Vishwanath temple in the 16th century. Now, the main suit is still in courts. But over the years, several verdicts have been given hope to the Hindu side, like the one that came out today from the Allahabad High Court. It dismissed a petition by the Masjid Committee. It paved the way for prayers to be continued as far as a cellar in the Gyanvapi mosque is concerned. The petition by Anjuman Intezamia Masjid Committee challenged the local court's order from January 31st that allowed prayers by a priest in the Vyas Khana. The mosque committee refuted the petitioner's version and said that no idols existed in the cellar, so there was no question of prayers being offered there until 1993. That petition was dismissed today by the Allahabad High Court, claiming that it had weak legal standing and in fact had no merit. Now, the cellar in question was sealed in the aftermath of the Babri Masjid demolition in 1992. Soon after the demolition, then Chief Minister Kalyan Singh, remember, had resigned. His government was subsequently dismissed, paving the way for President's rule. In the assembly polls that followed, a government headed by Mulayam Singh Yadav took over. The state government then cited law and order concerns and the cellar in this temple was sealed, but there was no written order. That find mentioned in the High Court order today. Let me take you through the details of the judgment that came to the fore from the Allahabad High Court. The first observation that was made by the court was that the appellant failed to establish prima facie possession over disputed property. In this case, that was the Masjid Committee. Puja offered till 1993 was stopped illegally by the state without any written order is also what the High Court went on to talk about. They said that the state government's act since 1993 of restraining religious worship and rituals was wrong. The High Court also said that Article 25 of the Indian Constitution guarantees rights that cannot be taken away by such arbitrary action of the state. Then they said that stopping worship and rituals by devotees in Vyas Khana in that cellar would be against their interest, and that is why it was problematic, which is why they said that there was no merit in this petition that the Intezamia Masjid Committee had put out. Now, this case has seen various court interventions so far. There have been stay on some orders, there have been extensions on some other, there have been challenges to some more too. So let's break this down. Let's break down what the legal battle has been in the recent past. Let's talk about 2022. There was an advocate commissioner's report that came to the fore, which spoke of the shivling-like structure in the Vazukhana. Remains of Hindu deities were found is what that report claimed. 2023, which was last year, the ASI conducted a survey there. They concluded that the pre-existing structure was probably destroyed in the 17th century and that parts of a pre-existing structure were reused for the expansion of the mosque. 2024, the cleaning of the Vazukhana was permitted by the Supreme Court. That was sealed 2 years ago. Remember, it still remains sealed, but at least that cleaning was done by a court order. Today, the Varanasi, the Allahabad High Court, in fact, a few days after the Varanasi court, both ruled that Puja was unlawfully stopped back in 1993 and will now continue. So what is next in this case? For how long are we going to be seeing this drag on in the courts of this country? Is there a solution in sight? We take those questions to our guest tonight.
The Honorable District Court of Varanasi, in exercise of its powers under Order 40, had directed the DM Varanasi as the receiver of the property and has also directed him to conduct puja. So there was no infirmity in the order of 17th of January and 31st of January, and therefore the Honorable Allahabad High Court has rejected their petition.
इजाज़त मिली होगी या छूट मिली होगी कि हम सुप्रीम कोर्ट जा सकते हैं, तो हम सुप्रीम कोर्ट अवश्य जाएंगे।
मुस्लिम द्वारा पक्ष द्वारा दी गई दलीलों को बलहीन माना गया है और उसको खारिज कर दिया है। इसका मतलब यह है कि पूजा जैसे वहाँ चल रही है जारी रहेगी। डिस्ट्रिक्ट मजिस्ट्रेट को जो अपॉइंटमेंट ऑफ रिसीवर किया गया उस प्रॉपर्टी का तहखाने का वो चलता रहेगा।
Joining me on this broadcast is the right stand, Harishankar Jain, lawyer of the Hindu side. Shahid Ali, president of the United Muslims Front, will be joining us shortly. And advocate of the Supreme Court, Kapil Sankla, joins me. But let me begin by asking Harishankar Jain, this is something that the Hindu side is claiming victory over. The right to pray continues, even though the rest of the issue is still going to be in courts, Mr. Jain. But as far as what the court observed today, when they dismissed the petition of the Muslim side, they said that what the government had done back in 1993 was completely illegal. And that perhaps is the most extraordinary point that came out of the four as far as the judgment goes.
Okay, basically I say there is no question of win or lose. Here the justice has been given because till 1993 Puja in Razi Taikhana was going on. That was stopped illegally by the government without any written order. There is no order in writing, and all of a sudden, after raising the fencing, iron fencing, the pujari was not allowed to go inside the premises, and puja was stopped. The court has allowed only that thing which was stopped in 1993. I want to make it clear, the court has not given any new right. It is restoration of right. I say it is restoration of right. The right which were curtailed, right which were taken away without any authority of law, that has been released by the court, by district court, and upheld by the Honorable Allahabad High Court. Second thing, the core issue in the entire petition is as to whether the present structure had been constructed after demolishing a Hindu temple. That is the wider question. And we are fighting for that. We have filed title suit. We have filed suit for darshan and puja. And everything is going on. Vyas's suit is very limited. He claims right only so far as Taikhana is concerned, cellar in the southern side of the building. Because I may tell you, this is 1551, the entire sijra of the family that is available. And since 1551 till date, there is continuity in the hereditary office of Vyas Gaddi. And Vyas was performing puja there. Since 1825 till 1935, in a decade of more than 100 years, the number of cases which will throw light on the question that in every case it was shown that Vyas was in possession over the suit property. Not only this, the Deen Muhammad case, which they rely, we don't rely, they rely, the Muslim side. In that also, the government had filed a sketch plan showing that there was Vyas Taikhana in 1935. And there is nothing, no change has taken place. And I may tell you one thing. I have placed on record a number of documents showing that every year Shanti Vahan Path is taking place, and for that purpose, Baas, Balli, etc., that is being carried out. So in every year, the Path is being performed, Puja is being performed. One day, Mahasingar Gauri Puja takes place. Muslims, I will make it clear to my Muslim side that Muslims had never been in possession over southern side of Taikhana. This is very clear. And only Vyasji and Hindus, they were performing puja. The court has based its finding, and court has limited only to that right. I am repeating, which right was curtailed by Mulayam Singh government in 1993 due to political reasons.
For over 3 decades now.
To reduce the right of Hindu.
Yes, for over 3 decades now. And Shahid Ali also joins us on this broadcast. And Shahid Ali, we were just having this discussion about what exactly this order today that came to the fore from the Allahabad High Court does for this particular case. Now, it may have limited repercussions as far as this particular cellar goes, but now we have the masjid side going on to knock on the doors of the Supreme Court, even when today the High Court said that your case has no merit. It has weak legal standing. There is enough and more documentary evidence, at least as far as this cellar is concerned, to show that the possession was always with the Hindu family, which was the Vyas family.
This is the statutory and fundamental right of every citizen of India to approach the highest court.
Sure.
In fact, there is hierarchy of judiciary. If one court decides a particular thing, then the rooms are always open for filing appeal. And thereafter, before the revision bench, and thereafter before the Honorable Supreme Court of India. So this is in fact provided in the Constitution, in the law. This is a scheme of the law. So no one should be perturbed if the Muslim party is approaching Honorable Supreme Court, or if they, I mean to say, my Hindu brothers approach the district court. At last, the rule of law has to prevail. At last, the verdict given by or propounded by Honorable Supreme Court has to be this accorded finality. So we all have been waiting. We all have been waiting. This is the one side. The other side is that, then for what? 1991 Place of Worship Act was enacted, and as long as that act is in force, my submission is, my take is that passing of a judgment pertaining to any mosque, any gurudwara, any mandir is absolutely illegal, and that contravenes the Place of Worship 1991. Because as long as same is a good law, same is a good act, then no one can pass any of the order, any of the judgment. So Honorable Supreme Court has to be knocked for this purpose.
Sure, and absolutely. Nobody is perturbed here. Everybody has the right to approach and explore all their legal options. There's absolutely nothing wrong with that. But many are asking the question.
Only the anchors are perturbed.
No, absolutely not, sir. Absolutely not. There are many who are asking.
We are not perturbed.
Absolutely not. There are many who are asking that is this being dragged on for much longer than it really should be? That's the question many are asking, which is why I asked you that. But let me also get in Kapil Sankla, who's with us on this broadcast. And Kapil Sankla, the 1991 POW Act is being spoken of. Is that an argument that will hold water as far as this particular case is concerned? Because while this case has been heard in different courts of this country, the Allahabad High Court on one occasion has also gone on to note that there is no material evidence on record, at least, that goes on to talk of a formation of a Waqf board or the creation of a mosque in this particular site.
Well, not only that, what is really interested is, as far as the act is concerned, and at various forums I have questioned the act, because the act basically creates a status quo, and we know that even the Honorable Supreme Court says that in civil cases or other cases, status quo should be for 6 months and then should be decided on merits. And here the act itself says, let's have a status quo and let us not disturb the status quo, which basically means that if there is a wound, let us leave the wound and let us not heal the wound. So as far as the status quo is concerned, in this case, that doesn't even help the other side, and the reason is this. Because since 1991, at least the Vyas family has challenged the right of the mosque to exist there. Since 1881, they have the documents to show that they are in possession of the basement of the Tehkhana, and that the southern side of the Tehkhana, the puja has been done consistently. Now for a moment, just think, if you're talking about status quo, what are we saying? That the mosque on the top and the mandir at the bottom should remain the way it is, and that in the light of the fact that the 4 ladies who had filed the case saying that once in a year they were allowed to do puja and once in a day they were allowed to enter the sanctum to do puja should also be permitted, that cannot be. And the purpose of the, now let us go at the purpose of the act. The purpose of the act is, if some place has been converted into another religious place, then that should not be disturbed. In this particular case, the temple has not been completely destroyed. It still exists. Not only it exists and there is a Shivlingam there, but also puja is consistently done and is sanctified as far as Hindu rituals are concerned. So as far as the act is concerned, that act does not help them, though I personally believe that act is a bad act and it basically festers wounds forever. But the second part of it is that since Vyas family, as far as the possessory right is concerned, are winning on 2 fronts. One, that they have documents since 1881 to show that they have been in litigation fighting or have a contentious issue with the mosque saying that this mosque should not exist, and that at least till 1993, admittedly, as the case of the parties are, that they were doing puja in that area and they still possess certain parts of the basement, which, as somebody just said, Mulayam Singh government just put some iron claddings in front and shut it down. But the property is still owned by them, the possession is owned by them, puja is still conducted there. Then how can you take away that right? So at the end, the only important aspect is this, that yes, any party in India has the right to go to the Honorable Supreme Court, but the orders of the District Court and the High Court are clear and based on cogent evidence and a clear interpretation of what the law is on the fact that the Vyas family has asserted their rights since time immemorial.
But Kapil Sangla, do you then think this is going to have repercussions or implications on the larger suit that is being fought as well?
Oh, I definitely think so. And I say this for two reasons. One, on your channel, I had already said this when we were speaking about the 4 ladies who had gone. I said that you have to see if there is cogent evidence to prove that the ladies were entering the premises and doing Hindu puja, then the question whether it is a mosque or not is a question that is a question on fact and also on the legal matrix as far as the law is concerned, and that has to be looked into, because if puja is being conducted, then it clearly is not a mosque, it is just a building in which namaz is being said or done, or whatever it is said to be done. And the second aspect is that as far as the property is concerned, now there is a question as to the ownership and occupation of the property. The Muslim side say our right emanates from a certain emperor who had come, broken down everything, built something. While the Vyas family says our right comes from, look at the khatas, look at the documents, look at the possessory rights and other documents that show that we are in possession. And third, as far as the religious sanctum is concerned, the fact that there are 3 sides, one a Muslim side that said that there is no Hindu artifact there, that was proven to be false, and now there are 2 Hindu sides. One says that I am doing puja at least till 1993 and I am still in occupation and ownership of a certain part of the premises, and the 4 ladies who say that every year we were allowed to enter and in any time once a day we were allowed to go there and do puja where there is a murti of Ma there, also shows without any inkling of doubt that the question of whether it is a absolute and 100% Muslim side is an argument that would fail in the longer run.
Shahid Ali, what do you have to say about that? Like I said, the High Court also has noted that there is no evidence on record. There is no evidence on record to talk of a work for the creation of a mosque. There are multiple testimonies that we've heard, documents that we've seen, pictures and maps that we've seen that all speak of a temple that existed there at some point. If that was the case and if it was demolished and a mosque was constructed there, that would be desecrated land. It can't be a mosque then in any case. Like Kapil Sangla was also talking of, that maybe it's just a building where prayers are being offered perhaps.
I'm really surprised. What kind of evidence they are talking about? Without the documents and the claim of either of the party. As long as the same is not tested.
So the Vyas family has given its evidence, sir. Vyas family has given its evidence. If we will take about Vyas family as far as possession and occupation is concerned, they've given their evidence.
The final verdict is always rendered by the courts after the evidences are adduced by both the parties and evidence is appreciated. Where is the appreciation of evidences? You have been claiming a particular thing as evidence. You have been claiming
a document that is unchallenged.
Sir, Mr. Kapil, I was completely silent when you were speaking. Now, please allow me.
I'm with you on this. I'm only saying that the documents are government
now,
documents.
as far as the report of ASI is concerned, that is also not the evidence until the same is this tested before the Honorable Court through the cross-examination, through the various methods. Mr. Sharma, Mr. Harishankar Jain also aware of that. Mr. Kapil is also aware of that. What is the procedure which is followed in the courts to prove a particular thing? So until unless these things or these claims are tested and tried and appreciated by the honorable courts, nothing can take place as that of the evidence. So saying so that the honorable court has passed an order on the basis of evidence or cogent evidence is absolutely illegal. My humble submission is, my contention is. Now I am coming to the second part. You have been alleging that the Mughal emperor had broken down some mandirs and all. From where this story has come forward? The Muslim rulers we have recently seen the example in UAE. The Muslim ruler have given the land to construct a mandir. So this kind of Muslim ruler, this kind of Islam preaches about. So 500 years ago, you have been saying that such things happened. We don't know. You don't know how that will be proved. That is also a matter of concern. So that is why by virtue of bringing an act in the parliament, these things were put to completely and halt so that we people of India may live in peace and harmony. So
Sure.
that Hindu
Sure, but you say that
Muslim
there
may not go forward.
there aren't evidences to support that claim, but there are several of those. Many would contest that there are there is documentary evidence like the Masjid Alamgiri that talks about how this was done by Aurangzeb back then. But I'm running short of time on this. I'm running short of time on this. I want to get in a word from Harishankar Jain as well. So as far as the larger dispute is concerned, we are seeing that both sides are ready to knock on the doors of the court, the higher courts, every time there is a setback in this particular case, and as is their right to do so. But for how long are we then going to be seeing this drag on in the courts of this country?
देखिए, matter is ripe for hearing. Commission report is there, SI report is there, Advocate Commissioner submitted his report. Now evidence has to be let by both the parties, and we are ready to prove to the hilt without any out of evidence against that this was a place where there was a temple which was demolished, and then the present construction has been raised. It is in no way a mosque but a simple construction where Muslims forcibly and illegally offer namaz. And they have no right to enter into the premises. That we will prove. And this thing has to be proved and judicially decided.
Sure. Now, Harishankar Jain, many people are saying that perhaps it's time for a compromise and out of court settlement. Is that something that you're on board with?
No, not the least. No question of any compromise. We can't compromise any inch of land of the temple. The land belongs to the deity. We are human beings. We cannot compromise the land of the deity.
Sure.
Entire land belongs to Lord Shiva. Therefore, we are not in a position to give and take.
Sure.
No give and take.
Sure.
And we
so no compromise. That's what the Hindu side says. That's also what the Masjid Committee has been saying.
Yes.
The matter is in courts at different levels, both from the local court in Varanasi till the Supreme Court. I have to leave it at that. I thank you all gentlemen for joining us here on this broadcast and sharing your perspective. We will keep a track of what happens next in the Kashi Vishwanath Gyanvapi Mosque legal title suit. Before now, it's time for a quick break here on this edition.